Welcome to this tutorial video. This video gives you an introduction to the domains fundamental rights and freedoms, participation in public life, and legal protection, access to justice and remedy of the Indigenous Navigators Human Rights and Environmental Due Diligence module. In this video, we introduce the concepts covered in the domains and the relevant human rights instruments. Domain: Fundamental Rights and Freedoms. The fundamental rights and freedoms covered include protection against arbitrary deprivation of life, disappearance, torture, and cruel, inhumane, or degrading treatment of Indigenous human rights defenders, the right to peaceful assembly, and the right to life as it relates to disaster risk reduction. Recognition of these fundamental rights are critical for the protection of Indigenous human rights defenders, including environmental defenders, who too frequently face serious abuses, threats, and harassment when raising awareness on the negative human rights and environmental impacts of their communities and their lands, territories, and resources as a result of business activities, and ensuring that Indigenous peoples can come together and freely express their views on business activities and related policies, plans, measures, laws, and implementation frameworks. Recognizing fundamental civil and political rights like freedom of expression, association, and access to justice is essential in the context of environmental and human rights due diligence. These rights enable Indigenous peoples and environmental defenders to defend their rights, including to their lands, territories, and other resources. The UN Guiding Principles on Business and Human Rights, or UNGPs, in Principles 1, 3, and 25 to 27, emphasize that states and companies must ensure these rights are respected to prevent harm and enable accountability. A key concept related to some of the questions under this domain is the concept of harmful acts. Both the national and the community surveys monitor the occurrence of any harm to Indigenous human rights defenders. Harmful acts here refers specifically to the following: killings, kidnappings, enforced disappearances, arbitrary detentions, torture, and strategic lawsuits against participation, also known as SLAPs. Indigenous peoples or individuals may also experience threats of harm. Threats are intentional behavior that causes somebody to fear physical, psychological, or emotional harm. It can cover a wide array of different actions, both online and offline. For example, it can be in the form of verbal threats, intimidation, harmful and stigmatizing speech, threats posted on social media or sent in text messages, online harassment, which can amount to hate speech, being placed on hit lists, red tagging, pictures sent showing that one's family is under surveillance, and death threats to oneself, one's family, or to a member of the community. The fundamental rights and freedoms considered under this domain are anchored in several important human rights instruments. As per the UN Declaration on the Rights of Indigenous Peoples, or UNDRIP, in Article 7.1, Indigenous peoples have the rights to life, physical and mental integrity, liberty, and security of person. These rights are enshrined in many human rights instruments. Some examples of key instruments that protect these rights include the International Covenant on Civil and Political Rights, or ICCPR, the International Convention on the Elimination of All Racial Discrimination, or ICERD, the UN Convention Against Torture, or CAT, and the Convention on the Rights of the Child, or CRC. Additionally, in the commentary to Principle 26 of the UNGPs related to the steps states need to take to reduce legal, practical, and other relevant barriers that could lead to the denial of access to remedy, it is recommended that states should ensure that the legitimate and peaceful activities of human rights defenders are not obstructed. The UNGPs recognize the critical role of human rights defenders as part of the business and human rights ecosystem, including their role in human rights due diligence and in facilitating access to justice and remedy. Questions under this domain assess whether there is a national law or policy protecting indigenous individuals when defending the environment or their rights in the context of business activity, and aim to record the existence of harmful acts against indigenous individuals while defending the environment or their rights from business-related human rights impacts. Some of the questions in the surveys under this domain align with Sustainable Development Goals, or SDGs, indicators, specifically SDG 16.10.1, on the number of verified cases of killings, kidnappings, enforced disappearances, arbitrary detentions, and torture of journalists, associated media personnel, trade unionists, and human rights advocates in the previous 12 months. The related questions and response options are structured in a way to ensure that the data collected can contribute to monitoring this SDG indicator from Indigenous peoples' perspective. Domain: participation in public life. Participation in decision-making is a recognized right of Indigenous peoples. Article 18 of the UN Declaration on the Rights of Indigenous Peoples, or UNDRIP, states that Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. However, for this right to be effectively exercised, access to information is essential. The issues covered under this domain therefore include recognition of the right to equal access to information, specifically environmental information, and availability and accessibility of information on environmental laws, policies, measures, and impact. Access to information is a legally binding right. It can be found in Article 19 of the ICCPR and is a required condition for effective and meaningful participation, including in policies and plans related to business activities. The Human Rights Committee, the UN treaty body that monitors the implementation of the International Covenant on Civil and Political Rights, provides authoritative guidance on how this right should be implemented. In its General Comment 34 on freedoms of opinion and expression, it clarifies that states need to proactively make government information of public interest publicly available. The state therefore needs to create procedures whereby people can gain access to information, for example, through freedom of information legislation. The UNGPs emphasize the importance of transparency in business conduct. Principles 3, 10, and 21 highlight that both states and businesses should support access to information about human rights risks and impacts in the context of business activities. While the legal right to access information applies to public bodies and is a state obligation, businesses are expected to communicate how they address human rights impacts, specifically to affected communities like Indigenous peoples. This transparency is essential for enabling meaningful participation and accountability. Clear, timely, and accessible information supports effective consultation, grievance processes, and informed decision-making. It is important to note that this domain focuses on access to environmental information. Environmental agreements and treaties such as Aarhus and Escazú have contextualized these standards to environmental matters. The Escazú Agreement, of particular relevance for Latin America, defines environmental information as any information that is written, visual, audio, and electronic or recorded in any other format regarding the environment and its element and natural resources, including information related to environmental risks and any possible impacts affecting or likely to affect the environment and health, as well as to environmental protection and management. The Aarhus Convention has a similar definition in its Article 2. Under this category, the questions monitor whether the right to access to information is recognized in national legislation, what kind of environmental information, for example on environmental and social impact assessments and environmental and human rights monitoring reports related to business activities or spatial and sectoral plans, is made available, and in what ways it is accessible. Questions also assess whether Indigenous communities enjoy this right by exploring whether environmental information is available and accessible to them in languages that they understand, in formats other than writing, in ways that are practical to access, at low or no cost, and provided in a timely manner. Domain: legal protection, access to justice, and remedy. The issues covered under this domain include access to justice and remedy for infringement of rights. Recognition of these rights is critical for protecting Indigenous collective and individual rights in the context of measures and projects related to business activities. This includes the ability to take legal action to litigate rights and seek remedy for human rights impacts, including when related to environmental harm to their lands and territories. Identifying and addressing barriers to seeking remedies for human rights impacts related to business activities and related measures, and ensuring that effective remedies are provided for impacts on Indigenous peoples' rights in the context of business activities. Access to justice and remedy. Indigenous peoples have the right to access to justice. This is outlined in UNDRIP and recognized in binding human rights instruments. Article 40 of UNDRIP notes that this right also entails the right to prompt decisions through just and fair procedures for the resolution of conflicts and disputes with states or their parties. These decisions need to give due consideration to the customs, traditions, rules, and legal systems of the Indigenous peoples concerned in international human rights. This is mirrored in SESCR's General Comment No. 24 on State Obligations in the Context of Business Activities. As we already touched upon in Video 1, the UNGPs emphasize that both states and businesses have roles in ensuring access to effective remedy when human rights are harmed by business activities. Under UNGP Principles 25 to 27, states must provide access to judicial, administrative, and legislative mechanisms, while businesses are expected to establish or participate in grievance mechanisms that are legitimate, accessible, predictable, equitable, rights-compatible, and transparent. These mechanisms should be available at the operational level, allowing affected individuals or communities to raise concerns and seek redress early. Ensuring access to remedy is a core part of both the state duty to protect and the corporate responsibility to respect human rights. Effective remedy. The Committee on Economic, Social and Cultural Rights, or CESCA, has provided important guidance on state obligations in relation to the provision of effective remedies for human rights abuses and violations in the context of business activities. Some of the key standards in this regard are: states must provide redress for rights violations affecting indigenous peoples. Judicial remedies should be independent, impartial, and accessible. Remedies must be available, effective, and timely. Reparation can include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. The views of affected indigenous peoples must be considered in designing remedies. Laws and policies should be improved if they fail to prevent abuses. Barriers to justice, like lack of legal aid, access to evidence, non-recognition of indigenous customary laws, use of language, or collective redress, must be removed. This is also reflected in the UNGPs in Principles 25 and 26. As part of their duty to protect against business-related human rights abuse, states must take appropriate steps to ensure, through judicial, administrative, legislative, or other appropriate means, that when such abuses occur within their territory and/or jurisdiction, those affected have access to effective remedy. States should take appropriate steps to ensure the effectiveness of domestic judicial mechanisms when addressing business-related human rights abuses, including considering ways to reduce legal, practical, and other relevant barriers that can lead to a denial of access to remedy. Specifically related to indigenous peoples, CESCA has clarified the following. States must ensure that indigenous peoples have access to effective remedies. These can be both judicial and non-judicial. They must be able to cover all infringements of the individual and collective rights, and they should be sensitive to indigenous cultures and accessible to indigenous peoples. Effective remedy may also be provided through non-judicial and administrative mechanisms. National human rights institutions and ombudsman offices with such a mandate can contribute to effective remedy. The UNGPs echo this in Principle 27. States should provide effective and appropriate non-judicial grievance mechanisms alongside judicial mechanisms as part of a comprehensive state-based system for the remedy of business-related human rights abuse. Companies also have a role to play in providing access to effective remedy. They should have in place or participate in processes that provide remediation through non-judicial grievance mechanisms, such as complaints or whistleblower procedures. This is enshrined in Principle 29, where it has been identified that business activities have caused or contributed to adverse impacts. Companies should provide for or cooperate in the remediation through legitimate processes. According to Principle 31 of the UNGPs, grievance mechanisms must be legitimate, meaning that they are trusted by stakeholders, especially those affected by human rights impacts; accessible, meaning that relevant stakeholders know about them and are able to understand and use them if needed, and feel that they can safely lodge grievances without reprisals; predictable, meaning that the grievance process is clearly defined in its process and outcomes as well as determined in its time frame. Equitable, meaning that aggrieved parties have access to resources necessary for fair, informed, and respectful participation in the process. Transparent, meaning that progress is clearly communicated to aggrieved parties and all relevant stakeholders. Rights compatible, meaning that they comply with international human rights instruments and frameworks. A source of continuous learning and based on engagement, meaning that companies continuously strive to improve grievance mechanisms. And based on dialogue with stakeholder groups for whose use they are intended, meaning that the design of grievance mechanisms and outcomes of specific cases are actively communicated to relevant stakeholders. Under this category, questions monitor the existence of national laws or regulations that provide access to judicial or non-judicial remedy for Indigenous peoples, including when related to environmental harm to their lands and territories, and whether Indigenous peoples have faced barriers when attempting to litigate rights and seek remedies for human rights impacts related to business activities. They also consider whether domestic judicial systems have held perpetrators accountable. Thank you for joining this video. Please explore the other video tutorials and materials on this page should you need further guidance in using the surveys and planning capacity building workshops.